নন প্রসিকিউশন ম্যাটার অফ
তুই মেনশনে দিয়ে দাও। Application of what type? What nature?
Substitution
Very good. Under the heading application, file টা নিয়ে দিয়ে দাও। Any other mentioning?
But this matter pertains to number 237. My Lord Justice Ajay Kumar Mukherjee.
I have determination.
Yes, my Lord.
Yesterday it was assigned to me. In the event it comes, I shall consider.
No, then 25th, my Lord, I mentioned a matter to your Lordship. The file is not traceable. Now, my Lord directed the officers, my Lord, to call for a report from the registrar. I understand the registrar report has not yet come. But this is a matter where by way of impersonation, more than 20 crores of rupees have been defrauded from my account. And Lord, Reserve Bank of India is involved, Axis Bank is involved. All the affidavits are ready. But in the event the file is not traceable, kindly put the matter as to
এটা আমরা
mention.
দেখেছিলাম।
Yes. The file.
Is just hand over the file.
But I think
ডিপার্টমেন্টে যারা আছেন তাকে ডেকে পাঠাবো আমার কাছে। একদম।
all the affidavits are with me, my Lord. My Lord, I'm sorry.
Ask them to come to my chamber at 1:15 p.m. today. ঠিক আছে?
As your Lordship. The earlier notice also I have given.
Yes, yes. I shall look into
My
it.
Lord.
Yes, call the list. Who is for the petitioner?
I am for the petitioner led by Mr. Niladri Shaha, my lord.
My lord, I am appealing on behalf of the alleged contemners.
Kindly see, my lord, the last order, my lord. Your lordship's order, my lord.
Give me a second.
Yes, my
My
lord.
You have received the financial statement?
No, my lord. Only 1st
My lord,
February, my
thanks,
lord.
this.
Only 1st February, my lord. I have been called by
You sought for 4 weeks time. I have given you
Yes,
5
my lord.
weeks time.
No, but my lord, another my lord, indulgence my lord, another for a period of 3 weeks. But see, in the meantime, the department is not sitting idle. There is some anomaly in the extension of pay scale of the petitioner that has been corrected. And my lord, on yesterday, my lord, it is sent before the DPPG for issuance of the PPO. So, my lord, this is the last stage. It will take hardly 2 weeks. My lord, kindly see the next document, which I have already handed over. My lord, there is a discrepancy regarding date at the top, but it was issued, my lord, I believe, my learned friend appearing on behalf of the applicant, my lord, they have also served with this memos, my lord.
Yes, my lord.
Yesterday, yes, madam, they are admitting. Yesterday, it has been sent to the DPP. He is the authority issuing PPO, my lord. He is supposed to issue the PPO. So, my lord, another humble indulgence, my lord, last opportunity. Lordship, kindly make it clear within a period of 2-3 weeks, the PPO will be issued. Then the rest portion is within the domain of the municipality to make payment.
What is the full form of DPPG? Director of
Director of Pension and Provident Fund. Right?
Take down.
Right. 60% is the duty of the concerned municipality.
I shall
The
see.
state will make an
I shall
exception for 40% of the.
If you take up the matter, it will be
Fine,
taken up.
I appear on behalf of the petitioner. Achieve an award of an industrial tribunal is under challenge this writ petition. So I am the concerned workman of the industrial dispute, which industrial dispute has been dismissed on the ground that I am not a workman within the meaning of section 2S of the Industrial Disputes Act. As such, the industrial dispute does not lie. Actually, I was appointed as
Just a minute. Give me a second. Exchange of evidence are complete.
Lordship. Matter is for final hearing.
Let me check. Affidavit in reply is there. What is the affidavit in opposition? Affidavit in opposition টা কোথায়?
We affirmed on 11th April 2016 by the respondent number 3.
দেখুন তো affidavit in opposition আছে কিনা? Who is for the respondent?
I appear for the respondent number 3.
Mr. Majumdar, have you filed your affidavit in
Yes, sir.
opposition? Kindly check your file.
Position and reply both were
Still with you or not? Probably it is not in my file.
not in file.
Probably. So far I have gone through. একবার ফাইলটা দাও ফেলে ওকে যদি দরকার হয়। This is the difficulty, which is why I first check whether it is there or not. We have received the copy of the affidavit in opposition, of
That's why
course,
Lordship filed.
which is why you have filed the affidavit in reply.
Lordship, may I then say this, Lordship, there is a pending can which was for expeditious disposal. Lordship, let that can be disposed of. Let them file another copy of the opposition and the matter be heard as it is.
Can will be disposed of along
Yes,
with
yes.
the read party certificate.
Yes, yes, no difficulty.
You have not filed. কি আবার কি কথা? Type of work. The writ petition should let an affidavit be filed within a period of 4 weeks. It is an order of 2016.
29th February 2000.
Affidavits filed on behalf of the parties be kept with the record. তো রয়েছে বলছে Justice Kapoor's order. No, he submitted a no affidavit in opposition reply that to have been filed 29/4 29/4/2016 কিন্তু 11তে বলছে the affidavits filed on behalf of the parties be kept with the record. রয়েছে তো।
There is an opposition affirmed on 11th April 2016. Maybe come with a photocopy of that affirmed, or kindly grants us leave to reaffirm whatever.
Yes, yes, yes.
Or we can come up with a photocopy of the affirmed affidavit.
Yes, yes.
You have a spare copy?
No, that's the problem. It's highly marked, badly marked. We can make a photocopy of the affirmed opposition and come.
আমারটা থেকে নিতে পারবো। আমার তো full screen। না যদি দরকার লাগে আমারটা থেকে নিয়ে নেবে, আমার তো dark কম।
It has been marked.
No. That's why I said they can take a Xerox copy from me, Lordship, it is not marked. Not marked. It is torn, but it is not marked. Xerox
Torn is
copy-
no problem.
Yes, yes, Xerox copy will be absolutely clean,
আসুন
only torn.
মুশকিল ব্যাপার।
Lordship, that of Lordship, so that
Whatever you like. No, it should be not true copy, authenticated. It should be with an endorsement authenticated by me. Put your full signature and date. I believe you both the parties have got no objection.
No. We have exchanged.
Call the next matter.
My lord, I am for the petition. My lord, the applications are for restoration, both the applications.
Who is the other side, sir? Sabu Saab,
My lord, sir, this is my affidavit of service.
give me the file.
Earlier occasions also no one appeared.
It is for the first time appearing before my court.
My lord, kindly see in that affidavit of service that chief health surgeon has refused.
Who has refused? আসুন Call the next matter.
Great.
Milord, in item number 4, I had instruction to be present for private response. But I found that instruction of the parties had expired. And the respondent number 3.
Have you intimated in writing? And what the legal errors?
Action from them, but I have just come to know from from 6 to 12 I appeared earlier. Some others have come to know that who has expired. So far, respondent number 6 is concerned, he has expired on 26/6/2024. And respondent number 10 has expired on 6 October 21.
So let my learned friend inform us within
Yes, yes.
7 days.
Who has died? Respondent number 6.
But he's
Died on
died on dot 26
26/6/2023.
and respondent number 10 Milord has died on 6/10/21.
6/10. লিখুন আসুন
Lordship, in this matter,
Lord, I appear for the respondent KMDA in this matter.
Lordship, in this matter, Mr. Kaulul Basu is appearing for the petitioner for his personal difficulty. I'm paying for not this week, Lordship. Kindly keep the matter on.
not the
Lord, in this, Lord,
what is the can one for?
can
I am not aware of the.
He's
can
not
one
aware.
to be heard along with the writ petition because
He's
the
taking some accommodation.
yes
Anyway,
yes oh my lord
not this week then.
then it comes to 10. Oh, can it be on 11th, my lord?
আসুন on behalf of the
My lord, I appear for the petition in this matter, my lord. On the last occasion, my lord, your lordship has directed me to serve, my lord, the GP. My lord, accordingly, my lord, in terms of your lordship's order, my lord, I have served the GP, my lord, with a copy, 2 sets of copy, my lord. Yes, they have accepted it and they have said, my lord, somebody will be engaged. So, my lord, I have done my part, my lord. And
Give
on-
me a second, let me see the order.
yes, on another day, my lord, I have filed.
Give me a second, sir. Intimate the.
My lord, in this matter, my lord, yesterday I have been instructed from the alert's office to appear in this petition.
Very good.
Yesterday,
You are not ready or not ready?
no copy, nothing. Yesterday I was instructed to appear in this matter.
2 sets of copy, my lord, yesterday I have served, my lord,
Not upon me.
to the GP office. And on the last occasion, we have served
Well, I
to all.
don't know anything about the GP office since I was instructed by the alert
Sir,
office.
copy. You have copy?
I don't have, my lord, I have to make Xerox and then, my lord, I have to.
Very good. Next, give me a copy. Review.
And my
What is scan 1 for?
Can one is, my lord, memorandum of review?
well, since it is review application, the entire record
Awesome. Take down. See how the state government is working. The court has to take a proactive action to inform the legal remembrancer, and on his request you have appeared. So what the state is, what the functionaries of the state are doing, what the GP office is doing, I don't know. I am sitting in court number 551 and sitting in a chamber at the 4th floor. This is my circle. I
Even
don't
they
know what
don't have claim lord
what
of the
will
court also, my lord. Yes.
be there has been a time limit. The time limit is fixed by this court. Call the next matter. None appears.
I appear on behalf of the petitioner.
Because I am appearing on behalf of respondent number 8, private respondent. Your Lordship, there is an order for filing affidavit in opposition. Lordship needs some more time, Your Lordship.
Why is CRR?
Lordship, what had happened was, Lordship, from their application for
Lordship,
before
I
the
appear on behalf
executing
of the
court,
workman.
they had filed an application for expeditious disposal.
Oh, it is that matter. 6 members of.
Yes.
Where the company refuses to pay the workmen.
Provided that the workmen are entitled to that. That is being tested in this case.
Lordship, if I may, before your Lordship hears the matter out, there is a 17B application. That has to be heard out first. Lordship, they have refused to pay, even under 17B, their company has refused to pay.
17B application is a can, which can?
Lordship, 3397.
3397 টা কোথায় গো?
3497.
3497 is there. কি আছে আগে দেখি তো একবার। বাপরে, সাংঘাতিক অবস্থা। রিপ্রেজেন্টেটিভটা কি এখানে? স্টেটসম্যান লিমিটেড।
But Lordship, along with this, kindly take the affidavit filed by the respondent number 5, which you find funded in the main petition. The Lordship will find the bread in page 11. Petitioner to pay the last drawn wages, that is rupees
You are referring impugned order. You are referring impugned order. Oh, just a minute. Let me see the order which is under challenge before this writ court.
That, your lordship.
I'm not going to decide the matter. What is the matter?
Lordship, that starts
According
at
the
page
present case
91, my lord.
stands rejected on
The impugned order. Page 91 of the writ petition.
Lordship, the relevant part is at page 119. Lordship, page 119, last paragraph.
It is on a reference, no.
What had happened was the workmen were terminated during the pendency of an industrial dispute. So under section 33(2)(b), before dismissal, they have to file an application under section 33(2)(b)
For
before the
approval.
court for approval of the dismissal, and they have to pay a 1 month salary. Lordship, the tribunal found that the application under 33(2)(b) was not maintainable. So, as per law, once that application is terminated, I am entitled to be reinstated.
As per law,
As per
once
law,
that application has been dismissed.
application is dismissed, I am liable to be reinstated along with all back wages. What the company did was the company preferred this present rate. Section 17B says that if you go up to the High Court challenging the order passed by the tribunal, you have to pay the last drawn wages to the workman. The Lordship, that
Last drawn pages for the entire period or only 1 month.
Lordship, that is the discretion of the court. The court can direct for the entire period or month by month from the date of the writ. Lordship, over here kindly take the prayers which has been there in the application 3497. We have asked for a direction to pay the last drawn wages from the date of filing of the writ application till disposal of the same. So we have not sought for the period relating to the arrears.
Lordship, may I
So
kindly
Lordship,
clarify?
kindly take
Let me find out
Lordship,
that is sir can
3497 page 11.
এই বার করে দাও 3497 কোথায় আছে কল্যাণ বাবু 3497 কোথায় আছে বার করুন ভেতরে পিছনে রাখতে পারেন দেখুন সব কটা ফ্যান ক্যান আস্তে আস্তে বার করুন দিন
Lordship, just one judgment I wanted to cite that 17B has to be heard first. That's the priority.
Let me find out the application, sir. Let me go through the application. Thereafter, I shall go. Show me the law. Thereafter, I shall. Sir, that much I have learned. I don't know whether I have learned it properly or not. So far as CAN 3497 is concerned, this is CAN 2 of 2016. What is the prayer? Is to pass direction of the representative to pay the last drawn wages, that is have to from the date of filing of the till disposal of the same. Yes. So many provision of section 17B.
This has also been dealt with. Your lordship has already, our order has been passed on the 26th of August 2016, but has been
My order.
but in this application, it was passed by Justice Subrata Talukdar, but in this matter.
I shall see to that. 17B. Kindly place, sir.
Payment of full wages to workmen pending proceedings in higher courts, where in any case a labor court tribunal or national tribunal might award direct reinstatement of any workman, and the employer prefers any proceedings against such award in a high court or the Supreme Court. The employer shall be liable to pay such workman during the period of pendency of such proceedings in the High Court or the Supreme Court. Full wages last drawn by him of any maintenance allowance admissible to him under any rule if the workman had not been employed in during such period, and an affidavit by such workman had been filed to that effect in such court, provided that where it is proved to the satisfaction of the High Court or the Supreme Court that such workman had been employed and had been receiving adequate remuneration during any such period or part of the court shall order that no wages shall be payable under this section for such period or part as the case may be. Over here, they have preferred the writ against an order of the tribunal, by which your lordship will find at page 91 of the main
Lordship may-
that order is there, and the relevant portion is at page 119. Your lordship will find that the applications have been dismissed. Your lordship, I will only draw your lordship attention to the last paragraph of page 119. However, before I conclude, I am constrained to reiterate that I am not going to decide how far the present office indulged into the alleged misconduct as enumerated in the charge sheet, as it has been proved that the present case arising out of an application under section 33 to the Industrial Dispute Act is not maintainable in law for non-compliance of the mandatory provisions mainly as stipulated under the proviso.
So you have pleaded that you remain unemployed in your application. You have used any affidavit in opposition?
Lordship, perhaps I do not have instructions on that, whether there was an affidavit in opposition which was filed or not. I'm on a very basic point, Lordship. Let us please take up the portions which my learned senior friend has just highlighted. Lordship, in my bare reading of the words, Lordship, the tribunal does not talk about reinstatement at all. And if there is no reinstatement, Lordship, what has happened, I'll just state, there was a murderous assault on the management of statesmen on the 3rd of January 2003 by several workmen. Now these workmen were subsequently they were terminated from their service. The Industrial Dispute Act states that if you want to terminate someone, you need to seek approval under section 33(2)(b). And a reference was also pending at that same point in time. So this 33(2)(b), Your Honor, I will place the entire judgment. It's a little longish judgment. It only
No, just make your submission, rather confine your submission with regard to the maintainability of the application.
Lordship, this is perhaps not a case where in a section 17B would at all be attractive.
By the impugned judgment, the labor court or the tribunal, whatever may be, has directed for reinstatement.
No. My approval was not allowed. That too on a very technical ground of short payment.
Sir, then how 17B is applicable, sir?
Because the law is so. 98 2002 volume 2 SCC 244 is a 5-judges constitutional bench which says what happens when a 33(2)(b) is dismissed. My learned friend comes here and says that I'm not entitled to be reinstated. Complete submission is constituted law, judgment of the bench. Lordship, this is 2002, volume 2, SCP 244. This was dealing with 33 2B. Kindly come to paragraph 14. Lordship, will kindly start from paragraph 14, when an application is made under section 33 to provide the
14.
yes, my lord. That's at page
Give-
253.
Hmm.
When an application is made under section 33 provides the authority before which the proceeding is pending for approval of the action taken by the employer has to examine whether the order of dismissal or discharge is bona fide. So this is relating to whether the dismissal is bona fide, whether it has by way of victimization or unfair labor practice, whether the conditions contained in the proviso were complied with or not, etc. If the authority refuses to grant approval, obviously it follows that the employee continues to be in service as if the order of discharge or dismissal never had been passed. The law is categorical. They cannot come and say that I have not been in service. And this is a constitutional bench holding this. The order of dismissal or discharge passed invoking the dismissing or discharging an employee brings an end of relationship of the employer and employee from the date of his dismissal or discharge, but that order remains incomplete and remains inchoate as it is subject to approval of the authority under the said provision. In other words, this relation comes to an end each year only when the authority grants approval. So it is deemed that there is no termination. If approval is not given, nothing more is required to be done by the employee, as it will have to be deemed that the order of discharge or dismissal had never been passed. Consequence of it is that the employee is deemed to have continued in service, entitling him to all the benefits available. I don't think there is a scope of dispute after this judgment.
Read the next line also.
Yes, my lord. This being the position, there is no need of a separate or specific order for his reinstatement. Category.
So it says.
So I don't need a separate order for reinstatement. The order is quite categorical. They have to reinstate me. Your lordship will kindly take one more, kindly take the affidavit in opposition of the respondent number 15, Suryavan Pandey in the writ. This section 17, the application was considered by Justice.
এই ওটা কি বলছে এপিন ইন অপোজিশন এপিন ইন অপোজিশন অফ
Lordship Suryavan Pandey, the respondent number 5.
Suryavan Pandey is the petitioner in Can.
Yes, my lord. Lordship will kindly take page 57 of it. That's one number 5. Page 57.
In Can 3497 of 2016, who is the petitioner?
Lordship Suryavan Pandey. Your lordship will find that at page 5. In the matter of Suryavan Pandey, son of state. Sorry, you must say signed it in confidential
Huh?
Prasad Pandey.
No, it is Ashok Kumar Pandey. You don't know who are absent.
3497. If lordship is perhaps seeing 3496.
3497 I am seeing. পারবে মামলা অশোক কুমার পান্ডে আছে এটা ওগুলোকে দেখাও তো
Lordship, may I just have a look?
এটা একটু ওগুলোকে দেখাও 3496
Lordship, is 3496, perhaps then Suryavan Pandey.
3496 is Suryavan Pandey.
Sorry, my lord. 3496.
তাহলে আমি কোনটা শুনছি রে বাবা
Lordship, 3496. Both are there. Both the applications are there.
that is 3496 and 3497 I am hearing. And what is Can 3 of 2024? 3497 টা দাও
Lordship, it's a substitution application, perhaps.
very good. Let me dispose of one after another. Yes, you are referring,
Lordship, I'm sorry, 3496.
no, you are referring affidavit in opposition of Surjavan Singh.
Respondent number 5 in the main petition. Surjavan Pandey.
Yes.
Kindly take page 57.
Yes,
Your Lordship will find can 3496 and 3497 both were being dealt with.
it has been disposed of.
No, my lord, it has not been disposed of.
Huh.
Lordship will kindly take the second page, page 14.
Huh.
Lordship will take the third paragraph. They take time entitled appears for statement is entitled to file opposition to can 3496 and 3497.
Affidavit in opposition has been filed.
I believe it has not been filed.
I shall dispose it in accordance.
Your Lordship will then turn over to page 15, page internal page 59, pending further consideration of the matter on affidavits. By way of an interim measure, this court directs statesman limited to make payments to its certified workmen. This payment has not been done. Your Lordship, the direction for payment was made. Now your Lordship will kindly take internal page 6 of that same affidavit. Lordship, affidavit of Surjavan Pandey, page 6. What page 6?
Page 6 of
Lordship, the affidavit of Surjavan Pandey.
in the application.
Lordship, in the affidavit of Surjavan, Lordship, the document which the Lordship was seeing, that is the affidavit of Surjavan Pandey,
Huh.
will kindly take internal page 6 of it.
Oh, internal page 6. Okay. Yes.
Your Lordship got paragraph D.
D for doctor.
Yes, my lord. Your Lordship will kindly take the last 3 lines. Lordship will kindly take a bit above because the contempt application has to start from after and thereafter. Lordship will find that 11 lines from the bottom. Thereafter, petition has made payments on various dates. And lastly, the petition made payment of rupees 1,11,804 by a check bearing number dated 7/4/2021 drawn on certain such. So they comply with the order, which is at page 57, and they make payment, the company. For the period January 2022 to April 2021, a copy of check read number certain such is annexed paper marked with the letter G. Thereafter, the petitioner has not paid any amount to me. The said contempt application is still pending. There is also a contempt application which is before your lordship. In total, the petitioner has paid 5,59,120 to me pursuant to various orders passed in the contempt application. Such amount has been made till April 2021. A sum of rupees 307,516 is payable from May 21 to December 2024. Your lordship is fine. Your lordship also sees with it the reply filed to this affidavit of opposition on behalf of the company. Your lordship will just take page 5 of the affidavit in reply of the statesman limited to the AO of the respondent number 5.
ये देखिए. No, this payment was directed to be made under section 17B.
In this very application which is before your lordship, that's why it is page 57. Page 57 is the order by which
That is an interim order.
that's an interim order.
So why I have not filed the contempt then?
Lordship, the contempt has also been filed, but the contempt has not appeared in your lordship's case. The contempt, I believe, was before a different court because the order was passed by Justice Calcutta.
So
we have-
yes, terminated.
Yes. Justice Calcutta has put on it. So we have sought for assignment of that matter, your lordship, but the matter has not yet come before your lordship. The contempt matter ideally should also come before your lordship.
So that is the business of the Honorable the Chief Justice. That I cannot do anything. You have to pray for that.
We have already prayed for it, it should come before your lordship also. But in the meantime, I just wanted to make it that if an
Sir, when you have not complied with the order, why for non-compliance of the court, sir, I can dismiss your writ petition.
Lordship, may I kindly place it, Lordship. Section 17B, Lordship, in my humble submission, is perhaps not attractive. Lordship, why I say this, section 17B, Lordship, it starts with, where in any case a labor court, tribunal or national tribunal by its award. Now this is very important, my lord. These are not any orders passed by the tribunal. This is an award. And only if there is an award, it directs reinstatement would a workman would be entitled for benefits such prescribed under 17. Unless it is an award. Lordship, this is a little different from my application under 33(2). And this is perhaps not a reference under section 10. Lordship, let us please take up what is an award, Lordship. Even the Industrial Disputes Act contemplates what is an award, Lordship. This is section Section 2B. An award means an interim or final determination of any industrial disputes or of any question relating thereto by any labor court, industrial tribunal or national tribunal, and includes an arbitration award made under section 10. So this basically refers to any application which is filed under section 10. Now let us see what is section 10. Section 10A. Voluntary reference of dispute to arbitration. Where any industrial dispute exists.
Section 10A. Capital A.
Industrial Disputes Act. Where any industrial dispute exists or is apprehended and the employer and the workman agree to refer the dispute to arbitration, they may at any time before the dispute has been referred under section 10 to a labor court or tribunal or national tribunal by a written agreement refer the dispute to arbitration. The reference shall be to such persons or persons including the presiding officer of the labor court, tribunal or national tribunal as an arbitrator or arbitrators as may be specific in the arbitration act. Now, Lordship, the legislation was absolutely clear what is the difference between an award and an order. Lordship, the analogy may be drawn between a decree and an order under the CPC. There are provisions of appeal, but there are two different sets of appeal. All do not go before the same judge, my lord. In my humble submission, Lordship, there are certain provisions under the CPC which is prescribed under Order 43 and Order 41. They cannot be read together. In the same way, unless we are faced with an award, which I have challenged, in my humble submission, Lordship, the workman would not be entitled to any benefit under 17B.
Take down.
Lordship, may I just state one more thing? Because my learned friend's submission is contrary to the pleadings, where he says that they are entitled.
No, this is a legal point, Lordship. I can take. I need not write legal points in my pleading.
এটা তো go out of the এটা তো lordship এর kind
কি এখন বসে বলতে পারবে কি এখন বসে বসে উকিল বাবুরা সব ঠিক করে হেল্প না করতে পারলে আমি কি করে কাজ করবো এবার মেন ডাব্লিউপি লেখো তো
Then
liberty to mention,
I'm afraid.
which is why liberty to
And
mention.
Lordship, I think this can be under instructions I'm submitting is perhaps an application taken out by us for expeditious disposal of the repetition because
Which is why I have asked asked them to submit a report.
Lordship, just one more indulgence. Statesman is trying to sell off all its assets so that they don't have to pay. I have made a supplementary affidavit disclosing how they are selling off all their assets. And
Hello, it will now the supplement. Let me come back after 5 minutes.
copy has been
may I submit in respect of item number 13 and 14. My two appeals have been
Item
taken,
number?
13 and 14. Well, two appeals have been taken up by court number 26.
What do you want?
But
Not
I
today?
want- Not today only.
Who is the other side?
Mr. Tarapoto Das, my lord, I shall intimate him. I was here, my lord, that matter may be taken up and I shall do it. But this is the position.
Who is item number 13 and 14? Who is there?
My lord, in
একবার বোর্ডে শো করো তো, ডিসপ্লে করো। 13 and 14, seeking accommodation.
But for this, the appeals have been taken.
Very good. 13, 14 not today. Call the list. Item number 11.
My lord, in item 11, I appear for the Madrasa Service Commission.
Very good. 11. Who is appearing in item number 11?
Also 11, also I am for the West Bengal Madras Service Commission.
Lordship, may kindly remember on 14th of February, Lordship passed an order for assignments before the Honorable Chief Justice. Now, all other matters have been fixed by your Lordships on 12th of March. So these two matters, 11 and 12, may be fixed again on 12th, along with other matters.
I have given him a liberty to approach the Honorable Chief Justice. I am
Exactly.
not part of
Correct. Lordship, may kindly have a look at Lordship's order on 14th of February.
any administrative order has been passed by the order by the Secretary. or the
Well,
order-
they have approached. I think my learned advocate on record might be able to say.
So this is the approach we have made to the Honorable Chief Justice. But till date, there is no order of assignment. This matter, two matters also, Lordship, in the.
Identical matter.
Yes, it is identical. Well, I should not say identical because there is a diametrically opposite points. Other matters, Lordships have taken a decisions. In these two matters, they are questioning that.
When the other matters are fixed on,
That is fixed on 12th of March. Well, that's the reason I thought that these two matters may also come with the other matters on 12th before your Lordship.
very good. Come on 12th.
Item 12, I appeal for the state.
Let the matter be listed on, let the instant matter be listed on March 12, 2025 under the same meeting.
Well obliged.
Can I get back?
Yes, sir. এটা ফেরত দিয়ে দাও 12 মার্চ এটা কি আছে দেখি ও ধরো ওই একই ডেটে রেখে দাও 12 রেখে দাও অ্যাসাইনমেন্ট ওই একই দিনে সেম অর্ডার করো এয়ার কোড কে আছেন
Yes, well, 12 would be same.
আগেটা যেটা বললাম লিখেছেন ওহো let the matter be listed on March 12, 2025 under the same heading দুটোতে সেম অর্ডার করুন yes 15 Dinesh Agarwal versus State of West Bengal.
I am kindly and you are continuing to ask to speak. The I can speak but not friend. Let's see, first of all, I introduce.
Wait. File দাও Just a minute, sir. এটা আইডিয়া নেওয়ার কত গো বউটা ঠিক করুন ভাই ইউ আর দিনে মিস্টার দিনেশ আগরওয়াল which for the state
For the state led by the under government.
you don't want to file a video opposition
But the writ petition itself is not it is misconceived, my lord.
Very good.
It is not maintained.
very good take your seat sir You pray for mutation?
No, no, I don't want some lordship. My application is that 15, 12 to 15 members of judges of this honorable court passed order in my favor. After that, Supreme Court had passed mandatory direction in the year 2023, but administrative officer have not complied that order. For once of right, I can prove in the open.
Well, I'm objecting to that, my lord. This is
No.
false allegation.
No. I can prove here. I can prove here, lordship, that for once of lordship.
What is your prayer?
My prayer is in those erring officials who have not complied the order, they should be punished, lordship, for their matter, for not compliance of the matter. My industry, family, financial life have already finished. I am contesting since 2001.
Sir, I understand your predicament. I understand your suffering. But what you have prayed before this court?
I am praying before this court. Pending matters should be complied by the officers as per the direction of the.
Then why have not filed the contempt petition?
No, my lord, just I am giving you a example. In the year 2008, when Egypt.
Sir, what do I do with an example? This is not a class. What is your prayer, sir?
Just direct them to comply, to fulfill my all applications. Lordship, Chief Justice.
Comply to fulfill all applications.
My prayers, which I.
Come to your prayer. Come to your prayer portion.
Yes, sir. Yes, Lordship.
If I do not understand your prayer, what do I do?
Just, my prayer portion is 23 to 25 Lordship.
What read out? What does?
Yes, sir, Lordship. A writ of in the nature of temporary commanding the respondents and each of them to forthwith certify and transmit to the honorable court the records of the case. The writ in the nature is mandamus to issue commanding the concerned respondent authority, particularly respondent number 1, and each of them act in the accordance with law to execute the lead under major mineral in favor of the petitioner.
To execute the lease under major mineral, it means what?
Lordship, major mineral dolomite mine. My prayer was of 1998. Several judges have passed the orders in my favor. Now, in my favor, Justice Ashok Das Adhikari, Justice R.K. Bag, Justice Vishwanath Samadar, and Mr. Mukherjee, Aniranga Mukherjee. After that, Supreme Court has passed in my favor to hand over the lease. In spite of.
To file contempt petition, why read petition?
No, read petition is just example.
আমি কিছুই বুঝতে পারছি না কি বলছেন বাবা।
Sir, Lordship, kindly allow me to speak in Hindi or Bengali so that I will explain that.
আরে বাবা আপনার যাতে আপনি আমাকে ব্যাপারটা বোঝাতে পারলেই হলো।
Lordship,
किसी प्रकार से समझाइए कोर्ट को।
First, I was listening very well and set up my limestone mines.
I am very happy for that. So what is your prayer? आप क्या मांगते हैं कोर्ट से?
They have cancelled my existing mines and industry in the year 2014 by overriding the order of the honorable.
Where is that order? वो order कहाँ है?
Order just.
आपको माइनिंग लाइसेंस था उसको कैंसिल कर दिया?
Mining license by overriding the order of the honorable.
अरे भाई माइनिंग लाइसेंस कहाँ है दिखाइए कैसे कैंसिल किया वो भी दिखाइए ना पहले। ये हमारा सारा दिन गया था।
Lordship, first my prayer 29 uh,
My lord, he appeared before the Honorable Supreme Court in person. The Honorable Supreme Court, my lord, directed.
As
My
a
lord, the Honorable Supreme Court directed the respondent authority to execute a lease deed in favor of the petitioner. My lord, your lordship kindly turn to page 282.
282.
282.
Huh.
It starts from, my lord,
282 is the order of
246, my lord, it starts from 246. State of West Bengal versus Messrs. Chiranjilal Mineral Industries, Bagdindi. My lord, 282, my lord, the operating portion.
just a minute, sir.
Annexures are not marked, my lord, pagination is not there, anything is not there. He implemented the person, my lord, in person, my lord, the respondent authorities. And those who are the retired, my lord, from the service, they have implemented as the
No,
respondent.
no. What is the order of the Honorable Supreme Court, sir? Please, please.
282, my lord, I'm reading, my lord.
We partly allow the present appeal and set aside the impugned judgment. Will execute a mining lease for Improvisato. The writ petition number will be treated as allowed to the extent indicated. So you execute. You have not executed.
No. Pursuant to the Honorable Supreme Court, my lord, order, my lord. No, এটা নয়, এটা থাকো না। Provisional grant of mining lease, my lord, executed on 11th December 2024. My lord, exhausted.
October 11, 20.
And it has been communicated to the petitioner, my lord, also by email and by post.
Just a minute, let me see.
That is my report, my lord. I have come with the
Let
report.
me see. Let me see. কি বলছে দেখি তো? Provisional grant of dolomite plot on Atto district in reference to of your original application and due compliance with the solemn order for the Atto. The complaint has been pleased to order that a mining lease for dolomite in respect of the owner for a period of 20 years is hereby granted provisionally to you, subject to fulfillment and compliance of the following condition for execution of an indenture of lease. Because to submit duly approved mining plan approved by the complaint authority, you are requested to submit clearance and the mining operations are to be undertaken only the request to submit clearance certificate and notice of the appropriate authority for use of the expense of
Got it. That letter.
आप satisfied नहीं है इसके बारे में?
My lord, he was asked to, my lord, deposit the, my lord, all these documents within 6 years, 6 months
हाँ.
from the date of communication of the order. That is 11th December. But he has not, my lord, complied that formalities. If you will comply the format, we will execute the deed.
Where I'll get that? Which clause? Within a period of 6 months from the date of issuance of this order. So 6 months has not yet elapsed. 11/12/24। तो ये तो ग्रांट किया है आपको।
Page 79 to 81.
Of
79 to 81.
$79 to $81.
May I read, my lord? Page 42.
Allow me to speak, Lord. This is the page 79. This is the. अरे बोलो ना ऊपर बोल वाले ने बेटा तो स्टाइल बोलते हैं दुकान के ओरिजिनल एप्लीकेशन अरे तो my lord, this is
the just a minute, sir. This is the page number 60 is a letter dated 26/10/2006, and this letter his page number 79. And this letter is 11/12/2024. They have granted provisional grant of mining lease. You submit the documents within 6 months.
I have already submitted, I can show that result. After that,
Huh.
they have issued second LOI.
2006 is not my lord, that has been cancelled. Thereafter, he made several petitions before it has been assessed before the appellate court, division bench, the honorable division bench imposed cost upon him. My lord, I'm showing my lord the judgment cost.
Sir.
My request is that, look, please, नहीं, लीड्स का बात है ना, मैं बहुत ड्यू रेस्पेक्ट से थोड़ा स्लो बोलना चाहता हूँ, इनके तरफ मेरा लॉर्डशिप, दिस इज द डॉक्यूमेंट.
Justice Samadar, your lordship, kindly see what order passed by my lord Justice Samadar.
Lordship, mining plan, environment plan is not a job. Mining plan बनाने में 6 लाख रुपया लगता है, environment बनाने में 4 लाख रुपया लगता है और 2-3 साल समय लगता है. फर्स्ट एलओए लोग इशू किया 2006 में. 2006 में इशू किया. आई ऑलरेडी सबमिटेड आफ्टर 4 years struggle, environment plan, mining plan, etc. I have submitted before them in the February 10. Okay, Lordship. मैं ये बोल रहा हूँ, ये बार-बार इनका एक तो है फेंको पूरी माको तेल, ना हो गए तुम हो गए बारे-बारे तेल. ये जो बार-बार environment plan, existing plan, ये फिर हमको 2 साल बाद फिर वो वापस ये देखा है. Lordship, there is a Supreme Court ruling versus government of Odisha and Bhutan Power Steel. Once a time, if LOI already issued. नहीं, मैं बता रहा हूँ. I have already, Lordship, kindly listen. I have already submitted mining plan, environment plan twice in the year 2010 and 2016, and they have come. And after third time, Lordship, several grant order has been annexed in the year. ওটার মধ্যে কোথাও মানে कहीं भी इनका provision नहीं है. Because of that, ये इसलिए लगा है. मैं उसको एक्सप्लेन करता हूँ.
Not only that, my lord, your lordship kindly turn to, there is no relevancy, my lord, with the writ petition. Page 35, it's a doc.
আমাকে জিজ্ঞেস করছেন, আপনি বলে দেন.
That's your lordship.
Lordship, मैं ये चैलेंज करता हूँ, मैं लैबनेट काउंसिल से ये चीज होता हूँ. क्या चीज करते हैं? चैलेंज करता हूँ. नहीं, उनको सेवरल टाइम्स हमने सुप्रीम कोर्ट में लिखा नहीं है. लॉर्डशिप, प्रेजेंटली लिखा है. Once I submitted 2010, secondly submitted in 2016. After that, Supreme Court when issued बारे ये mining plan, environment plan, they just move, मतलब just type of football. There is a ruling of the Supreme Court versus Bhusan. After serve the notice of content of the Supreme Court, they have issued the third LOI. Sorry, मेरा कोर्ट से ये प्रेयर है कि ये जो एयरिंग ऑफिशियल्स है, ये एयरिंग ऑफिशियल्स है, विदाउट और भी 15 टू लीज का डॉक्यूमेंट्स है जो मैंने डिवीजन बेंच में सबमिट किया. आपका पावर नहीं, मेरे को मैं पहले रिक्वेस्ट किया मेरे को थोड़ा लिबर्टी दीजिए, मैं एक्सप्लेन कर सकूं। सर काइंडली सी हाँ हाँ सर, मैं ये मेरा ये कोर्ट से मांग रहे हैं कि वो लोग, इट इज प्रूफ इन द रीड, they without bribe, at that time they wanted bribe rupees 60 lakhs, and it is clearly stated that Minister Partho Chatterjee was still in jail. First 50 lakhs wanted by the Partho Chatterjee and 10 lakhs by the authority. Now it became 1 crore 20 lakhs. मेरा प्रेयर ये है कि मेरा प्यास लगा, मेरा जिससे बोलो, मेरा ये प्रेयर है कि दे आर कंटेस्टिंग, स्पीक में only two, they are contesting with the support of the public money. They have spent rupees 5 crores towards the fees of the advocates. They have engaged 9 members of council before the Supreme Court. When I was alone in person, 9 members, Anand Grover was very most senior counsel and 8 members of another just lawyers were there. Now it is total violation of Article 40. I am already sold out my factory, my property, my flat. I have already lost my family. My wife has took divorce and lived with children in another country. Lordship, first I can, ये जो hearing officer है, ये देश को ऐसा है ना, इतना ब्राइब, बिना ब्राइब के कोई काम नहीं होता. Now, Lordship, there is a mutation. Lordship, every action has it is equal and opposite reaction. ये न्यूटन का बोला हुआ है. ये जो है, कोई आदमी अरबपति हो जा रहा है, कोई आदमी ये न्यूटन थर्ड लॉ ऑफ द मोशन. लॉर्डशिप, फिजिक्स केमिस्ट्री तो नहीं बता सकता, किंतु फाउंड इन द गूगल ऑल्सो जो एक्शन है और रिएक्शन है, ये जो आज इन लोग का जो प्राइस का मात्रा बढ़ गया है, इसका रिजल्ट ये है कि ये जो नहीं आप लॉर्डशिप, जब मेरा बात सुप्रीम कोर्ट में संजीव खन्ना सर में सुना पेशेंटली, और उन्होंने जो जजमेंट दिया, काइंडली सी फर्स्ट पेज ऑफ द ऑर्डर ऑफ द सुप्रीम कोर्ट, काइंडली सी.
কিছুতেই বলবে না যে প্রেয়ার ট্যাক্স।
Executing the lease date after compliance of all the formalities, you will have to submit all these documents. If
I
you
cannot
submit-
understand his prayer. That is the difficulty.
My 14th father will not understand me, Lord.
See page number 245. Kindly see page number.
My lord, your lordship, kindly see the my lord, what was the my lord, the respondent also. By name, he has included the persons those who are retired from the service.
Sir, you please take your seat.
Lordship, kindly see page 245.
Yes.
There are a numbers of the councils appointed by the hearing officials. The appointment was not by the state government, appointed by the hearing officials.
So if you have got any grievance against them,
yes,
in respect of a matter before the Honorable Supreme Court, you have to agitate before the Supreme Court. So where is the harm in appointing a lawyer? सर आप बाद में, सर मेरा टाइम बहुत प्रीसियस है, आप थोड़ा बताइए, आपका प्रेयर क्या है? बार बार ये पूछ रहा हूँ, आप क्या मांगता है?
आपके पास टाइम नहीं, मैंने एक प्रेयर में भी लिखा कि ये लीड को आप सीबीआई को भेजिए। मैं करप्ट हूँ कि ये लोग करप्ट है, एक्सप्लेन करके आपको।
तो ऐसे प्रेयर कहाँ है आपका? सीबीआई दिखाइए, सीबीआई को भेजने के लिए प्रेयर क्या है दिखाइए। ये जो बोलছে बाबा আমি কেন নিব
क्या आप
না না আপনি বলেছেন তো আপনি
20
বলেছেন
साल से मैं भी कोर्ट में लड़ रहा हूँ।
डायरेक्टिंग इन्वेस्टिगेशन ऑफ द अथॉरिटी बाय सीबीआई।
हाँ, बस clearly, मैं करप्ट हूँ।
that is his only intention my lord to harass the officers government officers it should not be permissible
I am contesting last since 25 years.
नोट करो, नोट करो।
get the
आप रेडी होके आइए।
नहीं, I am ready, मैं ऐसे ही हूँ।
ये आप नहीं बोल, अब समझ में नहीं आ रहा आपका क्या बोल रहे हैं।
मेरा कहने का मतलब है ये क्या बिना प्राइस के कोई काम नहीं करेंगे। मैं आप ये बोलना चाहता हूँ, आई एम आस्किंग दिस क्वेश्चन टू माय सेल्फ कि बिना प्राइस के वो ना माइनिंग लिस्ट देंगे, जो माइनिंग लिस्ट दिया हुआ मेरा घर का जो रिकॉर्डेड जगह था उसको भी इन्होंने वेस्ट कर दिया, मेरा नाम से एफआईआर कर दिया, तो पैसा नहीं देंगे तो चीजें नहीं देगा। मैं बोल रहा हूँ सर, ये एक्सप्लेन करे राजीव कुमार और सोमेश भट्टाचार्य क्यों कंपल्सरी लीव में किया ड्यू टू वांट ऑफ राइट। ये जब विधानसभा में मैटर उठा 60 लाख का, तब वो लोग चला गए कंपल्सरी क्यों गया वो लोग कंपल्सरी लीव में, व्हाट वाज देयर फॉल्ट? Every time they want
this is not relevant with your matter don't mix us up
no mixer लोग से ये जो बात बोल रहे हैं कि ये नहीं बोलना चाहिए, लॉयर बोलते हैं यही का बोला उचित गिव एंड टेक पॉलिसी, बट पुतिन प्रेसिडेंट ऑफ रशिया हैज इंस्टॉल्ड द ये कैमरास एंड ऑल थिंग्स जस्ट टू एक्सप्लेन बिफोर द कैमरा सो दैट एवरीबॉडी कैन नो what type of bribe. Lordship, kindly see the World Corruption Index report. India is 92 numbers of corruption out of 180 countries. हम और आप मिचलेने से सब आप मिचलेने से ये नहीं हो सकता कि इंडिया करप्ट नहीं है। 90 टॉप 92 में उसको क्या हुआ? क्या 8 केजी गेहूं देके 4 केजी गेहूं देके उसको सबको चुप कराया जाता है। मैं इंडेक्स दिखा रहा हूँ, वर्ल्ड इंडेक्स। एक बात क्या है, मैं आपका परमिशन लेके एक चीज पूछ रहा हूँ कि मेरे वतन के लोगों जरा याद करो कुर्बानी जो शहीद हुए हैं उनकी जरा याद। ওরা ওখানে বসে গুলি খাচ্ছে, এখানে এরা বসে ঘুষ খাচ্ছে। এই দেশটাকে ভেতরে কে সেভ করবে? বাইরে তো বর্ডারে অনেক মিলিটারি আছে সেভ করার জন্য, ভিতরে যে এরা उनका तरफ पूरा देश को खा जा रहा है। This should be punished also. All 15 numbers of judges have passed their order in favor of me, but they have not complied. They have not complied. Supreme Court को कहीं भी नहीं बोला है कि LOI इशू करो, वो ग्रांट बोला रिलीज करने के लिए। कभी 14Y डालता है, कभी 4C डालता है। ये न्यूज़पेपर में दिया है सर, कल सेवी का जो चेयरमैन थी उसके नाम से एफआईआर।
अरे रुकिए रुकिए तो So far as the page number 42, that is your memo dated 11/12/2024 is concerned, you have agreed upon to, rather you have uh, uh, you have agreed upon to execute an indenture of lease for compliance of the following conditions. Those conditions are mandatory in nature,
Milord.
in accordance with which act or rules.
Well, at the minor minerals, well, it's a prop, the major minerals, my lord. According to the minerals rules, well, it should be. Well, page 42, your lordship, kindly turn to page 42 of my report.
42,
I'm reading, my lord.
Huh.
Commissioner grants of mining fees for dolomite in number suggestion more the suggestion.
Huh.
In the reference to your original application dated suggestion, received compliance of the forum order dated 12 September 2020. Passed by the the competent authority has issued order that mining fees for dolomite in respect of the under mentioned area for a period of 20 years. It is hereby granted provisionally to you, subject to fulfillment and compliance of the following conditions for execution of an indenture of lease in accordance with law within a period of 6 months from the date of order. Extendable from time to time or valid grounds if any. Whether district, police station, Moja, or one of number, area. 20.87 area. You are requested to submit duly approved mining plan approved by the computing authority for the above stated area only. You are requested to submit environment clearance established consent to operate duly for the computing. The mining operations shall have to be undertaken only on the area made available from the end of the year and allowed to clear. You are requested to submit clear certificate and no official to the appropriate authority for use of explosives for execution of the duty. And we have to deposit on account of preliminary inspection for a mining lease under date non-ferrous mining and metallurgical industry mineral concession fee mineral fee and some further funds on this account as may data.
तो ये आप नहीं देना चाहते हैं?
Well, it has been communicated to him to
No, अभी
complete these formalities
समझ में
within 6
आया
months. But
ये आप देना नहीं चाहता?
these documents we shall issue.
सुनिए ना,
Execute that issue.
मेरा बात सुनिए, आप पहले सुनिए, A to H जो लिखा हुआ है ना, ये आप नहीं देना चाहते हैं?
In the year 2010, 2016, Lordship, I have submitted my submitted valid कागज.
तो फिर दे दीजिए ना.
नहीं, इतना easy नहीं है. It will take another 3 years to make the environment plan, to make the mining plan and approved by the authority. It will make and another 15 lakhs will be spent. This is not a job. Okay, I am ready to submit those papers. But those IAS officers have again submitted their Madhyamik Pariksha, higher secondary Pariksha, and then come to the chair before the IAS officers. Lordship, मेरे को 20 इसमें 15 साल लेसी है, 15 लेसी का नाम है, जिसको उन्होंने कोई हेरसमेंट नहीं किया. माने तुम्हें दाब अल्लाह, give and take policy. मेरे when my matter is there, they are imposing 14Y4C. What is 14Y4C? 14Y is the Jumidar Pratha and 4C is the agriculture farmers rules. That is totally set aside by the Supreme Court. They have imposed Lordship, this is the mining plan, this is the environment plan, this is the, it's not a job. ये ऐसे माइनिंग प्लान एक भावे होय तेरा इतना बड़ा बड़ा माइनिंग प्लान होता है.
पहले तो ये देने से आपको वो लोग तो नहीं दिया ना.
नहीं.
फिर सुप्रीम कोर्ट ने बोला फिर वो देना चाहते हैं.
देने बोला, एलओआई इनको देना नहीं बोला, इनको लीज देने बोला था. ये 2023 से सितंबर से 2024 तक बार्गेनिंग कर रहे थे ना, एक पुलिस के कम हो गया. जब इसको सुप्रीम कोर्ट का नोटिस दिए तब इन्होंने एलओआई इशू कर दिया। All annexes are annexed heavily. My residential complex become vast.
No, in the Supreme Court ने ऐसा बोला कि ये सब आपको देना नहीं चाहिए।
सुप्रीम कोर्ट ने 14/4 सब कमिट कर दिया, खाली बोला ये वाला दे दो, उसके बाद कहीं भी उन्होंने ये नहीं किया। हमने तो 5 करोड़ रुपए कंपनसेशन मांगा था लोग से। खन्ना साहब ने हमको पूछा 5 करोड़ का इनका सैलरी नहीं है, बोले सर इनको 5 साल जेल में डाल दिया।
जेल में डाल दिया?
नहीं, वो हाथ से बोले अच्छा ठीक है बाद में कुछ देंगे। तो उन्हीं का आनंद ग्रोवर हमको निकल के पूछा ये जो 5 करोड़ तुम मांगा ना 10 लाख मांगता ठीक है, जुडिशियरी में 5 करोड़ अभी नहीं।
तो why these are required? Under which provisions?
My lord, kindly turn to the Supreme Court's order again, my lord. I have annexed with my lord my report. Page 40, operating portion, my lord, again I am reading. Accordingly, and for the reasons stated, we partly allow the present appeal and set aside the impugned judgment with a direction. The government of West Bengal will execute a mining lease for 20.87 acres of land in favor of Messrs. Chiranjila such and such. The writ petition number such and such will be treated as allowed to the extent as indicated above. The claim of the respondent number such and such towards the balance area of the grant of mining lease will be treated as rejected and dismissed.
That I have understood.
Regarding
That I have understood.
7, my lord, we have issued that LOI.
But
to
the
execute
Supreme
the
Court,
district.
but the Supreme Court has stated, the Supreme Court has rather directed to execute a deed of
Lease
mining lease in respect of such and such.
20.87.
You are agreeable? Wait, you are agreeable?
Yes, my lord.
Then why are you putting this condition?
My lord, this is the condition, my lord, this is the procedure to follow, my lord. Unless, my
So
lord,
show me the relevant law.
but today I am not ready, my lord. Then your lordship will also find, my lord. By affidavit, your lordship, you don't. First of all, your
No,
lordship kindly.
the Supreme Court has
My lord,
directed
this
to
is not his
execute
prayer, my lord.
a mining
What is
lease.
the prayer in the writ petition, my lord? At first, your lordship kindly see. What is the prayer?
Sir, try to understand my question. If there is no prayer, the court can,
My
in
lord.
an appropriate
My
case, grant relief to an applicant.
Yes.
What I am on when the Supreme Court has stated, rather directed, for execution of a mining lease in favor of the writ petitioner, I am asking under which provision of law you are asking for compliance of these formalities prior to the execution of the deed of lease. That I intend to know. Is that available from your report?
No, my lord. These are not ready, my lord. Today, the first time I had come with the preliminary points. My lord, your lordship kindly see what was the, my lord, the respondents. What are the respondents, my lord? Respondent number 7, my lord.
Come on the next day
My lord.
on an appropriate instruction
Your lordship,
that
my lord,
under which provision of law you want this for execution of a deed of lease.
But the maintainability point of my lord should be kept open, my lord. Regarding this, my lord, it's a misconceived writ petition, my lord.
Right.
Your lordship kindly see respondent number 7. Yes.
Hard legal and hard petitioner, hard the
Respondent.
wait. The report the insertion of these clauses. आप चाहते हैं कि ये क्लॉज नहीं होना चाहिए। अरे भाई आपको मेरा सीधा सीधा बात ये नहीं बोल सकता है, इतना घुमा घुमा के तो बोलने से तो आपका यही तो तकलीफ है। ये यहाँ पे जो जो लिखा है क्लॉज, ये आप नहीं देना चाहते हैं। ये आप चाहते हैं कि ये आपको 20 साल का एक डीडब्ल्यू एग्जीक्यूट कर दे, यही तो बात।
ये गलत कर रहा है।
अरे भाई
जो नहीं आगे ভালো করে ল দেখে আসবেন ও এখন যে সরি
উনি অর্ডার দেবেন, উনি অর্ডার দেবেন তো উনার সঙ্গে কেন কথা বলছেন? আপনাকে আমি যেটা জিজ্ঞাসা করছি সেটা বলুন। आप ये जो क्लॉज 8 to 8 जो दिया हुआ है, इसके बारे में आपका तकलीफ है तो, और ये आप देना नहीं चाहता है, उसको दिखाने हक होगा ये देना मैंडेटरी है, बस खत्म। उस तारीख में आई है, उस तारीख में आई है, देख लेंगे।
Well, let it be kept in.
तो
The report kept in the report.
हाँ, that has been taken on record.
And
Report will kept on record.
Who has closed the point of mandate?
I am not raising this question as they
No
have
order has been passed. No order has been passed with regard to the
Really?
closure of mandate. Everything is open.
That
I
is
will grateful to everyone. I will come back on the 28th.
not in the pretty.
এইটা বোধহয় আগের মামলাটা ছিল।
Grateful, man. Grateful.
I am filing this one reply.
এই কি আছে দাও 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 16টা দেখি।
As your lord.
দেখি কি আছে। Who is for the writ petitioner?
I am for the
I am sorry, who is for the respondent? Who are you? কি বলেছেন? What is your prayer, sir?
arbitrary enhancement of rate and the arbitrary claim of failure of that is the my
The relationship is governed by which act?
Murshidabad State Management of Properties and Miscellaneous Provisions. And
That act provides for enhancement of rent.
yes, but my lord, that act altered act feature. Ideas of this act feature.
It has been declared. It has not been declared as a by ultraviolence.
No. It's pending. my lord.
So in the event what the prevailing law prescribes, in the event the landlord increases the rent in an exorbitant manner, what is the relief? Under the act, there is no provision for appeal.
No. Yes. Provision for appeal is there.
Huh.
Provision for appeal is there.
You availed that provision.
Yes, but
You lost the appeal.
No.
Then,
Only paying for arbitrary enhancement of rate.
sir, exactly I am so. In the West Bengal Premises Tenancy Act, there is a procedure for fixation of fair rent. In the event a rent is enhanced, there are provisions where to approach to deposit with the rent controller. So what I'm asking is an academic question, of course, without going through the record, because sometimes the judges learn from the lawyers. So what is the relevant provision of law in this regard when there is an exorbitant increasement of rent? You have to approach before a writ court, or there is a provision of appeal. That I want to.
There is a provision of
You have not availed of.
No.
Then why you have come before this court then?
Only arbitrary enhancement of rate. There is a no passing of any order. If any order is passed by the state official,
Very good.
then appeal is done.
Very good. I shall consider. Very good.
17, all parties are here, Lordship. I am appealing for the state respondents. Well, there was a direction for filing affidavits on behalf of the state respondents. I am praying for extension of time to file the opposition.
Come tomorrow, I shall consider.
My lord,
Come tomorrow, I shall consider. Time is over.
Yes, ma'am.
Yes, yes. So learned trial court believe the testimony of PW1 and PW5 and pass the order of conviction. Hmm. That I've seen. PW1 is the informant. But yes, PW1, PW5 and huh. PW5 made some positive allegations.
But my lord, I have seen my lord, page 24, the IO's evidence.
Huh.
All those were omitted before. He has omitted to state all those facts before the investigating officer.
Sorry?
The allegations which were made at the time of chief of the mother,
Huh.
those were missing at the earliest opportunity. My lord, kindly sees page 24, the cross-examination of the IO.
Hmm.
My lord, the last three paragraphs, PW5 did not tell me, such and such. No, your lordship will see. She did she did not tell me that conch shell bangle was broken. So there were some omissions at the earliest opportunity. The allegations which were there in the chief did not find at the earliest place at the earliest. Now, additionally, PW1 has stated something, but in cross, my lord, he has admitted that mainly due to poverty, the situation was like that. And the cross examination. Due to financial stringency, Ajit could not give proper food or clothing in time. My lord, page 12.
No. What is your submission with regard to the evidence of PW5 and PW, the IO? What do you want to say? PW7.
Yes, my lord. My lord, my contention was supporting my learned senior friend that the my lord, allegations that were made by PW5 at the earliest opportunity at page 19, my lord, that is most probably for the first time. Because the investigating officer has stated that these facts were not stated to him at the earliest opportunity when 161 statements were recorded.
Is it so?
Well, it's like that, my lord, kindly comes to the omissions.
No, where is the cross-examination to the effect that she was driven out from on many times? It has been stated to her or not? See page 19 and 24. They used to assault her. Is there any question to the IO that whether in course of our examination under 161 PW5 stated to you or not? There is no such statement. Question is whether the learned trial court is at all justified to accept this version of PW5 as a sacrosanct or not.
Yes, my lord. And my lord, there is additionally, if your lordship kindly comes to the page 4, the inquest report. My lord, the relevant portion is opinion, my lord, at page 5, point number 7. Of the paper book. Page 5, the last para, inquest report. Your lordship will see that this fact came at the earliest opportunity. There was no doubt so far as point number 7, opinion of the witnesses as to, on being asked the present witnesses who have signed and neighbors, it is told that the husband of such and such, Ajit, and the members of her father-in-law house used to torture her, and unable to bear the torture, she had committed suicide.
You are referring to which portion, sir?
My lord, page 5, last paragraph. Or my lord, kindly comes to inquest report, the column number 7. Opinion of the witnesses as to cause of death.
Oh, acha. উপস্থিত সাক্ষরগণের প্রতিবেদনে জানা গেল যে মিতা স্বামী বাড়ির লোকেদের নির্যাতন সহ্য করতে না পেরে. These are all hearsay. It is not a substantive piece of evidence.
No. So, I was just referring that At the earliest opportunity, this fact came out.
Page. Yes, I've gone. That I've already noted. Very good. That I've noted. Take down.
To get a report that whether the de facto complainants heirs would like to proceed with the matter appeal.
Yes. Report has come, madam.
My lord, report has come.
They are willing or not willing?
That is what I. They wanted some more time, I guess, because there are other heirs. They are saying that the other the other heirs are staying in different places, so he couldn't contact. He requires some more time so that he can contact all the heirs and would get.
So how long the court will wait?
Well, it gives another 1 week's time, and in the meantime, we will try to ascertain. Because we would say that to inquire everybody through over telephone. Now, phone is available now. That is.
Look, pursuant to
Seven is also similar type of matter, Malad, where Matlab only legal layer, the son has stated that he doesn't want to proceed with the matter. A report.
Ashun. Pursuant to the order দেখি ফাইলটা কি আছে দেখি।
But on the last occasion, we were directed to inform the victim.
In the last occasion also, accommodation has been sought for on personal account of it. The report dated No, I have not gone through. That's why I'm asking. Material means convincing material is not.
No, my lord, not that.
Not that. We shall consider. Ask Mr. Mondal to come on that day.
Initially, the case was registered under section number 417/3/2076. Promise to marry and all.
Oh,
So, my lord, there you lordship, I will satisfy.
very good. Now find out. Who is for the state?
Not
Mr. Bidyut Kumar Rai and Mrs. Seema Vishwas.
Tries engaging another place.
Let me see what is the report. Appellate number 1, Shankar Lodha expired on 18/3/1998, and appellant number 2, Arvind Kumar Lodha residing at Indore, Madhya Pradesh, but no one can say about his actual present address. The judgment against conviction. Let me see. পেপার বুকটা কি রেডি হয়েছে নাকি গো? Essential Commodities Act. Good. Convicted to suffer alive for 2 months and to pay fine of rupees 2000 each. কি হচ্ছে? খেলা চালিয়ে দিয়েছো নাকি? লেখো, on perusal of the report,
kindly seize your lordship's last order. Lordship has asked the department to submit a report whether the appellant has collected the paper book or not. Because on several occasions they have refused to do so.
Huh? After winter vacation? After summer vacation? We are in the month of March. And summer vacation will start from? So it would be better to fix it after in the next year. So what are you saying? It is a criminal appeal of 1997. You are asking for fixing a date after summer vacation. I am fortunate enough that you have not paid for after the winter vacation of 2025. What happened to Mr. Bandyopadhyay? Sir, what type of sickness may I know? Then, sir, make some alternate arrangement. I have every sympathy and pray to God for his early recovery. Please go, convey to Mr. Bandyopadhyay that the court is equally anxious with regard to this health issue, but I am to do justice with the appellant as well as the respondents.
The case under section 304 part 1.
Then, no, sir, it cannot be so.
What is the department's report?
Same has been served upon the state as well as the learned advocate for the appellant. लिखे जी but try to visualize the when the case has been, and I'm duty bound to dispose of the case. Pawan Kumar Mollik may not be की order ছিল দেখি দাও তো
No, they have been seeking time.
দেখি দাও তো Madam, you are not serious. On all occasions, you are taking time. What is your name? Payal Khana. Then, who is your senior? Where is Mr. Bhanjo? No, Mr. Suman Bhanjo has filed Wakalatnama. You have filed? Where is that Wakalatnama?
Department.
Show me the number, give me the number. Your senior does not hand over the brief to you. Where is his chamber? He has come to court today. Ask him to come tomorrow. লিখুন তো or otherwise you come ready. 2 years is sufficient. What are the charges? How many accused persons have been convicted? 4. How many witnesses have been examined? How the crime has been committed? Yes. A fight took place. And on account of such fight, died. What is the nature of weapon which has been used? Allegedly used rather. You have read the case. Why are you not carrying the brief?
Done properly.
Absolutely. Congratulations. So why not carrying the brief? Junior should be given an opportunity.
Absolutely.
How they will learn? At one point time, I was like her age.
But we all were.
Just come ready, at least with regard to the facts.
And she confidently answered that. And I was checking whether she was spelling it correctly or not. She's absolutely right on all the answers.
Madam, the last question, is there any case and counter case? No counter case. Very good. Thank you for your cooperation and keep the spirit on. Okay? And ask your senior to come ready. Very good. Call the next man. What's your good name, you say? Where do you reside? Howrah. In which area? 11. Under PS Dome. Very good. Once upon a time, I was a district judge of Howrah. Call the next matter. Who is the advocate on record? Where is that gentleman? I'll revoke his cancel. Vokrandama and appoint an amicus. No, I'm not so kind. I'm here to do the cases. Senior is not available, advocate on record is not there. What's your good name? Yes, your good name. Then who is Oishani Mukherjee? Mr. এই মামলা করবে না চণ্ডীচরণ চক্রবর্তীকে আরেকবার ডেকে আনো What are the charges, madam?
98,306, madam. Chandicharan Chakraborty is the husband of the deceased, my lord. And conviction under 498 and 306. 2 years and 4 years.
Sole appellant.
My lord.
I'm cancelling the vocalat now. Who has filed the vocalat now? Obijit De. Where is he? He's also ill. How old is he? Do you know him? How? See, at this age he becomes ill. Look, it is submitted by
26 I am appearing for that.
File read. মুশকিল আমরা করবে না কিছু না সারাদিন ভালো
এইটাই ready না
The earlier
start
thing the spider was taken up. There was some defect in the paper book. So Dr. directed the department to prepare a fresh paper book that I can collect. But so far as this present appeal is concerned, that is
give me a second. You have not collected the paper. Now you have collected. What are the charges?
charges were under section 306-498 and has been convicted under section 498. But so far as this present appeal is concerned, that was filed by two appellants right there. Appellant number 1, he was convicted under section 493A and 306. Appellant number 2, he was convicted under section 498A. Now, during the pendency of this appeal, the appellant number 1 died. Now, the death of the appellant number 1 that has been recorded by the lordship by an authenticated 18th of July 2024. So
18th of July
2024.
give me a second.
So the appeal is awaited against the appellant number 1.
8 July
8 July. Appeal.
yes rule has been issued
But not,
with regard to the enhancement of the sentence.
right to that. What happened? He was convicted under section 498A only, and he was punished with 2,000 rupees of fine. So that's why when this appeal appeared before your lordship found that the punishment was not in consonance with section 498A. So that's why a formal rule was issued. I replied to that. The rule was issued by your lordship to put this appeal in order.
You have replied to the rule? Where is that or what is the reply?
But the reply was filed.
এই করলেন রিপ্লাইটা খুঁজে বার করুন
The court. But kindly take the order dated 20th January 2025 that has been recorded.
Oh yes I got it. Affidavit as affirmed on 23rd September. You are the husband?
I'm not the husband.
He's the brother-in-law.
I'm the brother-in-law of the
And who has died?
husband.
Husband has
Appellant
died.
number 1 was the
So basically you have stated that you had no role to play in the alleged crime. That is your answer to the rule.
basically present appellant who has been convicted on the basis of 3 statements. So these statements are in the same field.
Give me a second. You take your seat for some time. Let me go through. May I know your good name, sir? Aniruddha? Take your seat, sir, for some time. Order book দাও এটা নাও এটা নাও ফার্স্ট ফাইলটা সেকেন্ড ফাইলটা যখন লাগবে আমি বড় করছি এটা। So out of 8 accused persons, 2 have been convicted.
Yes, ma'am.
Madhusudan and Durjodhan. Others have been acquitted. Madhusudan has been convicted under 498 and 306. And Durjodhan is convicted only under 498. Take your seat for some time. Thank you for your cooperation. Oh, it was taken up for hearing by me. Yes. Make it sufficient. The first file or second file টাকা Yes. Yes, Mr. Tiwari.
Can you take the complaint page 2 of my
Yes. Please.
I see moment on the start of my address also. Beg to state that today on 20, coming to the local traffic court government is something that at about 2 p.m. I came to learn from a boy of Joyra that my sister Sophie, wife of Joel, to
You know Bengali? You know Bengali? You can read Bengali? You can read Bengali? Then read this. And otherwise Mr. Ghosh will help you.
আমি শ্রী মোহনচন্দ্র দে পিতা ওয়ানশো অ্যাড্রেস অংশ আজ ইংলিশ 20/6/92 তারিখ বিকেল বেলা কালীগঞ্জ থানায় এসে লিখিত অভিযোগ করছে যে আজ দুপুর অনুমান 2 ঘটিকার সময় জয়রামপুরে এক জন ছেলের কাছে খবর পাই যে আমার বোন ছবিতে স্বামী মধুসূদন দে জয়রামপুরে তার নিজের বাড়িতে বিষ তেল খেয়েছে। এই খবর শুনে আমি এবং আমার অন্য ভাইরা জয়রামপুর গ্রাম আসি এবং দেখি যে আমার বোন মৃত অবস্থায় বাড়ির উঠোনে শুয়ে আছে। এখানে উল্লেখ থাকে যে আমার বোন ছবি রানীকে বাংলা আমার বোন রশি ছবি রানীকে বাংলা 1379 সালে জয়রামপুরে গ্রাম নিরঞ্জন দের বড় ছেলে মধুসূদনের শাস্ত্র মতে বিবাহের 3 বছর পর হইতে আমার বোনের উপর অত্যাচার করতে থাকে। এইরূপ দীর্ঘ 12 বছর যাওয়ার পর আমার বোন মধুসূদনের সঙ্গে কথা বলা বন্ধ করে দেয় এবং বিভিন্ন কারণে মধুসূদন দে সনাতন দে বাবলু দে
পরেশ দে বিপদ রঞ্জন দে
রঞ্জন দে সব পিতার মৃত নিরঞ্জন দে
আশালতা দে
আশালতা দে স্বামী মৃত নিরঞ্জন দে এবং বোনের ননদ দয়াবতী দত্ত স্বামী জয়ন্ত বিভিন্ন ভাবে বোনের উপর অত্যাচার করতে থাকে। এইভাবে অত্যাচার চলতে থাকার কারণে তাদের অত্যাচার রুখে করতে না পেরে আজ 6/93 তারিখে দুপুর 12টা সময় 2 নাগাদ বিষ পান করে আত্মহত্যা করে এবং ঘটনা ঘটে।
So at 14 hours, it has been industrial o'clock, which is why I requested you to read the original content. Because very often the translations are very bad.
But that one is over.
So what has been written?
It is 12, but one is overwritten. So
Leave that as it is. Very good. If you want, you can keep it with you.
the next page 9 charges are framed and taken close range persons under section 490 of the appearing at page 9.
ultimately trial bonds. Basically, this
For the present, we are concerned with Durjodhan. So we have to see whether the prosecution, from the prosecution evidence, any overact can be established on the part of the Durjodhan or not. Am I correct?
Yes.
Yes.
Durjodhan was convicted only on the basis of four statements. The prosecution witness number 2 were the brothers and the mother. Now, in those witnesses at the time of deposition, they stated that once upon a time, Durjodhan is convicted in
So show me the relevant portion, sir.
So on the basis of deposition only, and in those depositions, they have categorically stated that they have not seen Durjodhan inflicting that.
Sir, first paper. Just a minute. You are saying because learned trial court in the impugned judgment has referred those versions. Very good. Show me the relevant depositions.
Yes. First, my lord, kindly take page 10. This is an deposition of an independent witness. This is I am placing just to show the relationship between the deceased with her in-laws. Can you take page 10?
Yes. Then give me the exhibit 5. I believe it is not required for you. He was not declared hostile.
In that, there are 14 prosecution witnesses. Out of that, 4 prosecution witnesses have been declared hostile.
PW1.
PW1, he has not been declared hostile.
But he has supported the case of yours.
Right.
Then what is the effect? No, what is the effect?
Basically, the prosecution has not been. I mean, what I am just trying to impress upon your lordship.
No, why are you referring PW1?
I am referring PW1 just to show that the deceased, she has in the cross examination that is coming out that she was going through some mental trauma because of she undergone miscarriage twice. And she was going.
Sir, read the third line of the examination chief.
Madhusudan and his brother-in-law used to make good behavior with you. So basically, there was a good relationship between the deceased with her in-law.
So despite such statement, he was not declared hostile. So what would be the implication then?
I mean, the prosecution witness is not supporting the prosecution story itself. But that is definitely helpful for the defense.
It goes against the prosecution. After this version, the PW1 ought to have been declared hostile. He has not been. So, this version, Madhusudan and his brother-in-laws used to make good behavior with Chobi. It supports the case of the defense rather. Yes.
But at the time of cross-examination, some things are coming out, which has been at the time of cross-examination of the prosecution witnesses who have not been hostile, declared hostile. They are also deposing in the same way.
Anyway, Mr. Tiwari, you make your argument on your own way. I must not be an obstacle to your argument. There is nothing to be referred to PW1.
What I just wanted to please, my lord, the cross-examination where it has been stated that Madhu's wife got some mania of untouchables. Madhu's wife did not allow the children of his husband's other brothers to her due to her mania and dispute. And the dispute between Shobhi and her husband, other brother's wife, over the same mania as because she had no children, as other wife to narrate to her.
Sir, read the third paragraph from the bottom.
I did not third paragraph. I did not see any assault or torture upon Shobhi by any inmates of Madhu. Madhu's mother is aged lady and she used to reside at her younger son's house.
Is it helpful to you?
Basically, this is the prosecution method. This is not supporting the prosecution.
So I'm asking whether it is helpful or not helpful.
I'm just placing each and every. What I thought I should be placing.
Very good. Make use of it.
May I place a PW2? So basically, on the basis of the statements of PW2, PW3, PW4, and PW5.
Just a minute. PW,
2, 3, 4, and 5.
PW is 2, 3, 4, and 5.
PW2 is the elder brother of the
Other matters are my. You want to place which one?
PW2, I'm skipping the first paragraph, and the main is the second paragraph.
Hmm.
After her marriage, she used to reside at her in-laws' house. She also used to visit our house for about 3 years. The brothers of Modu used to assault upon Shobi after 3 years since the date of her marriage.
Hmm.
Her mother-in-law did not provide swearing to her. One village challenge took place over the said torture and assault upon Shobi by her in-laws. The said assault and torture gradually increases upon Shobi. My sister Shobi used to narrate her plight before me, and I also came to learn the said incident from the public. Whenever I used to visit her house, she used to narrate her plight that on 20th June 93 at about 2:30 p.m. we came to learn that my sister was lying on the courtyard of Modu and some foul smell like poison was coming out of her mouth. Thereafter, I rushed to the house.
PW2 is the informant.
No. PW2 is a de facto.
Yes, that is the.
That is the informant.
I beg. Thereafter, I rushed to the house of the Modu and saw the same incident. Thereafter, I went to local PS at Calicut and reported this incident to the second officer. I filed a written complaint before the local PS. One Mani wrote the written complaint under my instruction, and the same was read over and explained to me. Witnesses identified his signature on the written complaint marked as exhibit 1. Thereafter, I had been to the house of Modusudan after accompanying by police. Police had sent a dead body of my sister after turning it up and down. Wrote something. Witnesses identified his signature on the inquest report. This signature be marked as exhibit 2. Accused Vibhod Bonjon, Sonaton, Gujaran, Bablu, Swanso, they are present on the dock. My said sister Chobi was married to Modu in the year 1379 BS. 1379 BS is equivalent to in English calendar, that is 1970. The incident took place on 20th June 1990. So that is after 20 years of marriage. So 138 presumption does not apply in mine. I did not state before.
Presumption of?
138.
130. Okay.
I did not state before anywhere as to what I have stated this before this court in my examination that the brothers of Modhusudan had started assault and torture upon Shobi after 3 years since the date of her marriage. I am stating before this court for the first time. I stated in my examination in chief this day regarding the assault, torture, and learning it from these incidents from the public. And my sister used to narrate her plight to me. I used to visit her house, and when she used to come to my house, what I'm trying to impress upon your lordship, all those assaults they have not seen. They have heard it from someone. They have heard the plight of their sister.
How can they see?
Well, basically,
assaults are being inflicted at her matrimonial home.
They have not seen. Not a single complaint has been made during all this time. In this 20 years, she was married for 20 years. Not a single complaint has been filed before the.
Say like that is absolutely.
And what I am trying to impress upon your lordship, all those depositions they have been saying that the thing assault that was committed by Gujran, they have heard it from someone. So they have not seen me inflicting that in. So that is a kind of weird thing.
Death occurred after
20 years. The marriage took place in 1379 BS, which is equivalent to 1972 in English calendar.
20 years.
The incident took place on 20th June 1990.
And what about the hearsay? Where from will get that?
My lord, can you take page 14?
Yes, sir.
The second last paragraph. I am stating before this court for the first. My lord, can you take the second line? This day regarding the assault, torture, and learning about the said incident from the public. And my sister used to narrate her plight to me when I used to visit her house and when she used to come to my house. I was at the house of Modhusudan for about 15-20 minutes. Thereafter, I went to the local PS. When I came back to the house of Modhu again, then it would be about 3:30 p.m. It was at the house of Modhu in the second time after dark. I did not state anything over the death of my sister Sophie at the house of twice. Our village, Madhya is a big village, one so not so important.
Let's show me the relevant portions, sir.
Yes.
I'm not asking you to compromise with the interest of your client. That I'm not asking, but show me the relevant portion.
Can you take page 16?
Yes.
What I am emphasizing on paragraph, third paragraph.
Yes.
Not a fact that my sister Sophie got one thing that came out at the time of deposition that the another sister of the informant, the de facto, she also committed suicide at their house at one relevant point of time. So what I'm trying to say is that this is not a, I mean, this kind of mental illness, what they were going through, that cannot be disregarded at all.
Is there any cross-examination to that?
In the cross-examination that came out, that her is another sister, she also committed suicide in their own home. Can you take paragraph number 4? Now, in the
My one sister-in-law, Jutika, also took poison and died there.
so
These are
thing
three
is,
persons.
there are 3 persons basically who commit suicide. So the fact of mental illness or some mental trauma that cannot be disregarded at all. Why those persons severely committed suicide? But an allegation was brought at the time of deposition that she committed suicide because an auspicious occasion happened at the house of Moses. Now, that was a Shadbokhan ceremony where the deceased was not allowed to participate. An allegation was brought. So she was not allowed to take part in that occasion, and due to this, she got some pain in her mind, and which might have driven her to commit suicide. My lord, in that regard, I am placing the last paragraph, page 16. I do not know whether my sister Chobi got any pain in her mind as because she could not participate on the auspicious ceremony like Shadbokhan or to this incident. Other depositions were made where it was stated that she was not allowed to take part in that auspicious occasion that was in her in-laws house, so that's why she got some pain in her mind, and that's why she was driven to commit suicide. But in the examination, cross-examination, one of the elder brother, who is the de facto here, he is also saying that he doesn't know whether her sister got any pain in her mind.
This is all about PW2.
PW. Now, kindly take page 18. This is a PW3. Subodh is a younger brother of the deceased. Now, kindly take page 19. This is the cross-examination.
Just a minute. Yes.
Can you take the second paragraph?
Page number?
19.
19.
19.
Yes.
The
Please.
mental condition of my sister was not so good after the demise of her 2 children. The abhorrence revived at the mind of Chobi after the demise of 2 children. The state sister Chobi had got some mania like Chuchibai. So basically, she underwent miscarriage twice. After that, she got some mental problem, which might have driven her to commit suicide, where the present appellant has no role to play. But in the complaint, a case was tried to be made out that there was a very quarrelsome relation between the in-laws families and the deceased. Kindly take the next paragraph, where the brother is saying, I do not know whether any quarrel took place between the sister and her other in-laws, as because my house is situated in another village, Toronto. So one of the brother is saying he had no idea about any such incident during this 20 years. Kindly take page 20.
Read the next paragraph, paragraph number 19.
After the demise by Sister Chobi, we, the brothers, had discussed how to proceed and how to file this case before this court. That also shows some deliberation, indication of deliberation. The brothers discussed and they filed this case.
What does mean?
And what I'm trying to impress upon your lordship is they discussed, they might have some cloud of suspicion can be imposed, saying that they discussed some deliberation must be.
So it was not spontaneous.
It's not possible.
So it's an outcome of afterthought.
Yes.
You have missed that paragraph.
Kindly take page 5.
Just a minute. Page 20. PW4.
PW4, Shoshan Khali, she's the mother of the
Mother.
mother.
Just a minute. Yes, sir.
Kindly take the second time.
Yes.
After the marriage of Shobik with the said Motu, she resided at her in-laws' house. The said marriage was solemnized in the month of Falgun. When my daughter gave birth of a female child, then my son-in-law used to make assault and torture upon my daughter. My son used to visit the house of my daughter, and I came to learn from them. We had tried to settle up the matter by village shalish, but the accused Motu did not obey the verdict of the said shalish. My said daughter Shobi had been murdered about 6 years ago. I, along with my sons, had been to the house of Modu, so and so, found that my daughter was lying on dead on the courtyard of the said Modu, and we got some bad smell of the poison. Now, can you take page 21?
So what do you want to say with regard to his examination chief?
So some allegation has been said, but there is a line I came to learn from them. She has also never witnessed any kind of torture upon her daughter. She has not witnessed on her own eye, in her own eye.
Read one second. In appeal, don't make so hurry. It's not a bail. Read one second.
First paragraph.
Entire process, examination chief.
After the marriage of Chobi with the said Modu, she used to reside at her in-laws' house. The said marriage was solemnized in the month of Falgun. When my daughter gave birth of female child, then my son-in-law used to make assault and torture upon my daughter. My son used to visit the house of my daughter, and I came to learn from them. I had tried to settle up the matter by a village shalish, but the accused Modu did not obey the verdict of the said shalish. What she has tried to say that the husband of the there is no allegation.
In chief, there is no allegation against Duryodhan. My friends. How to do the cases, I don't know.
Can you take page 21?
Yes.
But in the cross-examination, can you take the third paragraph from the bottom?
Anything against Duryodhan? Then why are you showing? We are concerned with the role of the Duryodhan. Kindly check whether you have in our examination in chief, she has stated nothing against Duryodhan. Whether in exercise of your own wisdom you have taken something from his mouth, that I don't know.
From the entire evidences, the only place, let us cut short the matter. The only person who has stated about Duryodhan is PW5. That also he speaks about an incident where this Duryodhan had inflicted.
No, madam, he will get you a chance. Let Mr. Tiwari may please have. So nothing in cross.
Right.
Very good. Then come to next.
The same thing what I'm saying. She has also admitted the fact in a cross-examination that she lost two of her children. So that's why she got some.
Show me the
My lord, the third paragraph of the law.
page number. Yes. Yes. My said order got adherence. Very good. Then PW?
PW 5.
PW 5.
So can you take the third paragraph?
Hmm.
But there is a specific allegation against Duryodhan.
Hmm.
One boy from Joyrampur reported us that Duryodhan, brother of Motu, had assaulted my elder sister, causing fracture injury on her head. This is the only thing.
So where?
The third paragraph from the top. Or the second last paragraph from the top.
Yes, yes. Causing fracture injury on her head.
Right. But she was not taken to the hospital from the cross-examination. Can I take the cross-examination?
PW 5. Fracture. Yes.
Can I take the cross-examination? Third paragraph.
Hmm.
We did not intimate to the local police as one Duryodhan, brother of Motu, had assaulted my sister, causing fracture injury on her head. We did not give any application to any Gram Panchayat Pradhan of our locality. We also did not submit any application to the Gram Panchayat of Motu Gram Panchayat. Once my elder sister.
Who is PW 5, sir?
PW 5 is
Another brother.
brother of Pradeep.
Yes.
Next paragraph. Once my elder sister felt ill, we took away her to the hospital at Katua. I did not take away my elder sister to any hospital when she sustained her fracture injury on her head. So no complaint was filed. She was not even taken to the hospital. So there is no scrap of paper which can corroborate the fact that she sustained an injury on her head.
Yes.
So can I take page 37, PW10?
Who is that gentleman?
The doctor who did the autopsy.
Yes.
The said dead body was identified by Constable so I found no external or internal injury on the dead body. Stomach contained white color liquid with half digested rice so bad smell was present. I preserved viscera for clinical examination. In my opinion, the death was due to ingestion of some unknown poison to be confirmed by clinical examination.
Yes.
So the cause of death is due to taking poison and there was no external injury. So can you take page 8?
Page?
Page 8 of the table.
8.
8.
What is there?
Can you take the third row?
Yes.
Second point, cranium and spinal canal. The first box, scalp, skull, and vertebra. There is a remark healthy.
All are healthy.
Yes. So there was no external injury at all. So what I am submitting, in order to commit a crime under section 490, I should have done something which has driven the woman to commit it. So there must be two acts. The first thing is the act which has compelled her to take a step to commit it. So first action is she committed suicide. The only test in order to convict Mutluthon that is to be looked into, that whether the injury that was inflicted on her head, whether that has driven her to commit suicide. But immediately after, before her death, there was no such injury. Neither such injury is supported by any medical evidence.
You are referring to 498A.
490
Let us see once.
explanation key.
Yes,
Any, this is okay.
please.
Whoever being the husband or the relative of the husband of a woman, subject such woman to cruelty shall be punished with imprisonment for a term, which may extend to 3 years and shall also be liable to fine. Explain. For the purpose of the section cruelty use, any willful conduct which is of such nature as is likely to drive the woman to commit suicide or cause grave injury or danger to life, limb, health, whether mental or physical, to a woman. So there must be some willful conduct. First thing. Second thing, this willful conduct should drive the woman to commit suicide. In our case. So whether the willful conduct of inflicting injury that has driven the woman to commit suicide or not, that is the only case that. And it must be direct and directly connected. These two incidents. If that was the case, I inflicted an injury and only in order to save herself from this injury, she has committed this suicide, the case would have done. But this is not it. May I jot down my point? During a matrimonial life of 20 years, not a complaint of domestic violence or any kind of torture by anyone that has been. Second thing is the conviction. I mean, the PW5 in her examination, she has stated that the Mutluthon, he inflicted an injury on the head of her daughter, sister. That is also an example. He is saying that learn from a boy from Noida. So this is an example. He has not witnessed. After the incident, she was not taken to the hospital. Not a single complaint to the police. Not a report was filed.
No, when the injury was caused, that was also not stated.
The date is not specified.
If it be immediately preceding to the suicide, that could have been relevant.
That could have been. Third thing is, no follow-up. I mean, her head injury, that is not coming in the medical evidence also. The victim was undergoing some mental trauma. That is coming from the cross-examination of all of the witnesses. So, I mean, the witnesses of her family, I mean, the family members of the deceased. In her cross-examination also, they have admitted the fact that she was going through some mental trauma because of the death of her child.
You concluded, or you have to show some relevant portions of the trial court judgment.
In the trial court judgment,
why the learned trial court held you guilty?
The learned judge held everything. The learned judge has dealt with every point very.
Come tomorrow and show me that portion. It will be taken up at 2 p.m. Ashun. Do it under the heading part of matter. Under the heading part of matter. At the top of the list. Under criminal code. Under criminal. Just show me the relevant portions of the judgment of the learned trial. Hey, Kulna, এটা আমার কাছে পাঠিয়ে দিচ্ছি।